Welcome. We are about to begin a very careful and a very detailed exploration of one of the most persistent and complicated cold cases in modern American history.
The 1975 murder of Martha Moxley.
Exactly. This is a story that, it spans more than 4 decades. It weaves together these threads of extraordinary privilege, of celebrity influence,
And, profoundly inconsistent alibi.
and a truly exceptional sequence of legal challenges. It is a remarkable journey through the criminal justice system, and it's one that, for many people, still hasn't reached a satisfying conclusion.
That's absolutely right. Our goal today is to meticulously analyze the sources that lay out the facts of this case. When a story gets this level of public attention, the documentaries, books, constant speculation, it's essential to rely only on the factual record.
Right.
The specific evidence presented in court and the very complex legal rulings that really define the case's trajectory. We need to go past the headlines and get into the specifics.
And before we get into the details of the investigation and all the legal challenges, we must pause for a moment to remember the victim herself.
Of course.
Martha Elizabeth Moxley was only 15 years old when her life was tragically cut short. This happened on October 30th, 1975, in Greenwich, Connecticut. We need to analyze the events surrounding her death with full recognition of the deep tragedy and, well, the enduring grief that her family has suffered.
Setting the scene is so crucial here because the location itself, it shaped the entire investigation from the very beginning. Belhaven, one of the most exclusive and affluent neighborhoods in Greenwich, Connecticut. And that setting, that wealth, meant that the events of that night immediately attracted international publicity. This was never going to be just a local news story.
And that celebrity component wasn't just about money, it was intensely personal, wasn't it?
It was. The Skakel family, who lived right across the street from the Moxleys, was connected directly to, well, American royalty.
The Kennedys.
The Kennedys. The Skakel children were the nieces and nephews of Ethel Skakel Kennedy.
The widow of U.S. Senator Robert F. Kennedy.
Exactly. And that connection meant this case carried a political and cultural weight that prevented it from ever truly fading into obscurity, unlike, countless other cold cases.
That extreme celebrity status, it really influenced every phase of this process, didn't it? From what many sources describe as a sort of inadequate and cautious initial police handling,
To the aggressive media coverage and the immense financial resources later dedicated to both the prosecution and, for decades, the defense.
it created an environment where it seems the usual rules were sort of suspended.
So how do we structure this extremely dense material for you? The sources really map out 4 major historical and legal themes that we need to analyze.
We'll start with the murder itself and the stalled investigation that defined the period right after 1975.
Then we'll move into the decades-long interval. The case went cold, but it was vigorously kept alive by the media, by private investigations, and public pressure. That all led to the case reopening in the 1990s.
And our third phase, the highly controversial one, is the 2002 trial and the subsequent conviction of Michael Skakel.
Finally, we have to meticulously navigate this legal labyrinth of appeals, counter-appeals, and really surprising reversals that ultimately led to the state's decision to just dismiss the case in 2020. It's a winding path where the legal facts changed over and over again.
Okay, so let's unpack the initial events of that terrible evening, October 30, 1975. This was the night before Halloween.
Mischief night.
Right, Mischief Night, a time for teenage pranks, a little bit of low-key mayhem. What were Martha and her friends actually doing in Belhaven that night?
Well, the evening started out very typical. It was relaxed. The sources confirmed that Martha left her home with a group of friends.
Just normal teenage stuff.
Exactly.
Yeah.
They were involved in classic neighborhood pranks, ringing doorbells, toilet papering houses. The group eventually made their way over to the Skakel residence, which was directly across the street from the Moxleys' home.
And the Skakel house was, by all accounts, a bit chaotic that night.
It was full of young people, very little supervision. And the dynamics involving the Skakel brothers themselves, Thomas and Michael, proved to be immediately crucial.
So what is the last confirmed event before Martha vanished? What do we know for sure?
The last verified sighting of Martha Moxley involves Thomas Skakel, Michael Skakel's older brother.
Not Michael.
Thomas. According to testimony provided by their mutual friends, Martha had been flirting with Thomas, and they ended up kissing. The final account places them together at approximately 9:30 p.m.
And where was this?
She was seen falling together behind the fence with Thomas. Specifically, this was near the pool area in the Skakel family backyard. After that, No one who testified saw her again.
So Thomas Skakel is the last known person to have seen Martha alive. That puts him immediately under suspicion.
Immediately. And the next morning, on Halloween, the tragedy was confirmed.
Her body was discovered.
Yes. Chillingly, it was found right beneath a tree in her own family's backyard.
Her own.
The proximity to her home just made the tragedy all the more personal and shocking for the entire community. The initial observation of the crime scene immediately signaled a brutal, violent attack.
And the specifics of the evidence gathered at that scene are critical to understanding the eventual charges that were filed decades later.
They are highly specific and very disturbing. The sources confirmed that Martha's pants and underwear had been pulled down around her ankles.
But the autopsy?
The subsequent autopsy determined conclusively that there was no physical evidence of sexual assault.
So the scene may have been staged to look like one.
That was one of the theories. The cause of death was definitively identified as blunt force trauma and stabbing. She had been repeatedly and violently struck.
And the murder weapon is perhaps the most immediate link to the Skakel residence.
That is the single most damning piece of physical evidence established early on. Pieces of a broken 6-iron golf club were discovered near her body.
A 6?
Yes. The autopsy showed that she had been both bludgeoned and stabbed using the broken shaft of that club. And crucially, that 6-iron was identified and traced back directly to a set of golf clubs owned by the Skakel family.
A set that was kept at their house right across the street.
Exactly.
So within a very short period of time, police had identified the weapon, its owner, and the last person seen with the victim. That should have led to rapid charges, but the case, it just stalled almost immediately.
And that really speaks to the power dynamics at play in Belhaven. The initial police focus landed squarely on 2 individuals who were right there.
Thomas Skakel.
Thomas Skakel, because he was the last person confirmed to be with Martha, and the other was Kenneth Littleton.
The families live in Tudors.
Right, and Littleton had only started working at the Skakel home mere hours before the murder took place. His arrival was coincidental, but, highly suspicious.
So why did the initial investigation fail to proceed if the physical evidence was so compelling? This seems to be where the insulation of wealth and influence played its first major role.
This is perhaps the most significant insight from that early phase. Thomas Skakel was an undeniable prime suspect, but his father, Rushton Skakel, immediately refused police access to Thomas's school and mental health records.
You just shut it down.
Completely. This obstruction from a powerful family member, combined with what was perceived as a reluctance by authorities to aggressively pursue a politically connected family. It meant that the primary investigative window closed almost instantly.
They couldn't press the main suspects?
Exactly. So no one was charged, and the case quickly went cold. It allowed this ambiguity and all these questions to just fester for decades.
It's fascinating how the sources highlight that the case really only survived in the public sphere through the work of media and true crime authors during this long, cold period.
The media acted as the life support for this case. Several high-profile books were published about the murder during that time, ensuring that Martha Moxley's story remained culturally relevant.
Dominic Dunne's novel, A Season in Purgatory, in 1993.
Right, which used details so close to the facts that it kept the pressure on the Skakel family. And then came Mark Fuhrman's nonfiction book,
Murder in Greenwich, published in 1998.
And that one openly named Michael Skakel as the killer. It cited numerous missteps and errors made during that initial 1975 police investigation. These books, they weren't just for entertainment, they were actively pushing for the case to be reopened.
This brings us to the second pivotal phase, the dramatic reopening of the case. And what's stunning is that the catalyst for the renewed official investigation wasn't new DNA evidence or some kind of confession.
No, it was a completely separate event involving the Kennedy family.
Pure media fallout.
That's right. In 1991, William Kennedy Smith, another Kennedy relative, was tried for rape in Florida. And during that time, a rumor surfaced.
A rumor that was later proven completely false.
Completely false. The rumor was that Smith had been present at the Skakel house the night Martha was killed. And even though it was baseless, the resulting intense, renewed media focus on the Skakel home and the 1975 events. It forced authorities to take another look at this cold case.
And ironically, the Skakel family's attempt to mitigate the damage by commissioning their own internal investigation, that actually ended up providing the fuel for the official prosecution.
That is the central irony of this whole story. Rushton Skakel hired a private detective agency, the Sutton Associates, in 1991.
And the goal was to clear the family name.
That was the goal. But the resulting Sutton report, when it was eventually leaked to the media, became explosive.
Why? What was in it?
Because it explicitly revealed that both Thomas Skakel and Michael Skakel had fundamentally changed their stories over the years. Their accounts of their activities and whereabouts on the night of the murder were now significantly different.
So their alibis had shifted.
Dramatically.
Yeah.
And this revelation of shifting alibis was the definitive trigger for the renewed state investigation.
Let's hone in on Michael Skakel's evolving story, because the changes he made were self-incriminating and, well, deeply strange.
Michael Skakel's claims evolved from these vague denials into a highly specific and disturbing narrative. He eventually claimed that he had not only been near the Moxley property late that night,
But that he had climbed into a tree?
yes, a tree situated near the Moxley residence. And he claimed he was engaged in window peeping and a private act, what he himself called a shameful act.
And the timing of this.
He claimed this was happening from approximately 11:30 p.m. to 12:30 a.m.
Why was that specific timeline and location so detrimental to his defense?
because it placed him precisely within the window of time when the murder must have occurred. And it put him in the general vicinity of where Martha's body was found the next morning.
Potentially the very tree under which she was discovered.
Potentially. So while he wasn't confessing to murder, he was admitting to being present, alone, and engaged in this furtive act right near the crime scene. And this completely contradicted his earlier, much vaguer alibis.
For the prosecution, it was the perfect narrative wedge.
Absolutely.
This atmosphere of changing stories was then compounded by direct testimonial evidence that emerged later, specifically from the time Michael Skakel spent at the Elon School.
The Elon School testimony provided the dramatic, emotional centerpiece of the prosecution's case later on.
Tell us about the Elon School. What was it?
It was a residential treatment center in Poland, Maine, for troubled youths. Skakel was sent there for 2 years, starting in 1978. This was after a drunk driving arrest in New York.
And what came out of his time there?
2 former students from Elon provided evidence against him. They testified that they had heard Michael Skakel confess to the killing,
A direct confession.
admitting that he used a golf club.
And one of those students, Gregory Coleman, provided a quote that immediately summarized the alleged arrogance and sense of entitlement that fueled the prosecution's whole narrative.
Coleman testified that he heard Skakel brag about the killing and explicitly say, quote, "I'm going to get away with murder. I'm a Kennedy." Now, whether that's true or not, that quote served as powerful evidence of motive and intent in the minds of the prosecutors. The idea that Skakel believed his family's position shielded him from any real justice.
I think we need to spend a little more time establishing the context of Michael Skakel's troubled background. It led him to a place like Elon, and it helps us understand the volatile family environment he came from.
That background is critical because it paints a picture of systemic dysfunction, and the sources link that directly to the lack of accountability in the family.
So what do we know about his childhood?
Michael Skakel was born in 1960, the fifth of 7 children. His mother died tragically from brain cancer in 1973. He was just a young teenager.
Just 2 years before the murder.
Exactly. And he began abusing alcohol very shortly after her death. It seems he was, self-medicating his trauma. He struggled profoundly in school, failing out of multiple institutions, and was later diagnosed with dyslexia, which had gone unrecognized until he was 26 years old.
So we're looking at a child struggling with profound loss, untreated learning disabilities, and severe addiction, all while living in this highly affluent but chaotic setting.
Precisely. His own cousin, Robert F. Kennedy, Jr., later provided more context. He described Michael as a small, sensitive child who grew up in an extremely difficult environment with a harsh and occasionally violent alcoholic father who both ignored and abused him.
And the general environment in the house?
The consensus from neighbors and even some family members was that the Skakel children were largely unsupervised. But critically, they had unlimited amounts of money.
That's a dangerous combination.
It creates a perfect storm. You have affluence that insulates them from immediate consequences combined with a profound lack of parental guidance or psychological stability. It's the context that makes the later behavior, like going to Elon and the alleged confession, more tragically understandable.
And despite this cloud of the murder hanging over him, the sources indicate he did eventually try to build a life for himself after his time at Elon.
He did seek reform. He eventually attended Curry College, earned an English degree. He achieved sobriety in his 20s after going to multiple rehabilitation facilities throughout the 1980s.
And he even became a competitive athlete, right?
Yes, he pursued speed skiing, competing internationally and trying out for the demonstration team for the 1992 Winter Olympics. These later achievements, however, they couldn't erase the focus on his troubled youth and the lingering questions from 1975.
So with the combination of the shifting alibis and the testimony from the Elon students, the pressure mounted, and the state finally decided to pursue formal charges. The method they used to get to an indictment was, well, it was quite unique.
Yes, in June 1998, Connecticut convened a one-man grand jury.
Explain what that is for listeners who might not be familiar with the term.
It's a rarely used legal structure where a single judge is appointed to conduct a secret, intensive investigation into a matter of public concern. In essence, that judge acts as both the investigator and the grand jury combined.
And after 18 months of reviewing the evidence,
the judge determined there was sufficient cause to charge Michael Skakel with murder.
He was arrested in January of 2000. But because he was 15 at the time of the murder, he was initially charged as a juvenile. That classification didn't stick for long, though.
No, that was a pivotal legal battle. While he was arraigned in juvenile court in March 2000, the prosecution successfully argued that because of the severity of the crime and the age of the case and the complexity, he should be tried as an adult.
And a judge agreed.
A judge agreed in January 2001. That meant the trial, which began in May 2002 in Norwalk, Connecticut, was held in Superior Court, exposing him to a far more severe adult sentence.
Skakel's defense stood on his alibi. He claimed he was at his cousin's house during the critical time of the murder, but the prosecution, they heavily relied on his own shifting narrative. Specifically, that taped book proposal we mentioned earlier.
That taped book proposal, where Skakel had attempted to chronicle his life story, became the most intensely contested piece of evidence in the trial.
The jury heard a portion of it.
They did. They heard the part where he discussed his activities that night, including the admission of being in the tree near the Moxley property, engaged in that private, shameful act.
We must reiterate, as the sources emphatically do, that Skakel did not confess to the murder in this recording.
No, he did not. He was confessing to something else entirely.
And this distinction is crucial because it leads us directly to the core controversy of the trial, the allegation of prosecutorial misconduct during the closing arguments. This tactic arguably swayed the jury.
It is central to understanding why this conviction was later deemed unreliable. During their closing arguments, the prosecutors used a modern, computerized multimedia presentation. The sources detail how they took Skakel's exact words from that taped book proposal.
Specifically, his expression of panic.
Right, and they overlaid those words onto graphic, shocking images of Martha Moxley's dead body at the crime scene.
And the alleged manipulation came from the selective editing of his own words.
Exactly. Skakel had stated in the audio tape that he was afraid he might have been seen jerking off in the tree, and that this fear had caused him to panic.
But that's not what the jury saw.
No. While displaying the gruesome images and implying a murder confession, the prosecutor strategically omitted the phrase jerking off from the transcript that was displayed to the jury.
So they deleted the context.
They deleted the crucial context. And by doing that, the jury was led to infer that Skakel was expressing panic and fear related to the murder and a cover-up, rather than the shameful act he admitted to committing nearby.
The defense argued this was a deliberate tactic.
They argued it was designed to mislead the jury, to transform an admission of indecent behavior into an admission of homicide.
That's a powerful claim, that the state intentionally distorted evidence to secure a conviction. How did the prosecution later defend such a controversial tactic when it was challenged on appeal?
They were very firm in their legal defense of it. When the defense challenged this as misconduct, the prosecution argued they were engaged in nothing more than appropriate and effective advocacy.
Just doing their jobs, essentially.
In their official brief, they defended the move by stating that by placing certain pieces as evidence, like the crime scene photos, next to the defendant's words, the state was simply making explicit the inferences it was asking the jury to draw.
So they were connecting the dots for the jury.
They said that using these visual aids was just the job of an advocate, not a distortion of evidence. And this argument itself is a key point of contention for you to consider. Where does advocacy end and manipulation begin?
Despite the contention over the tactics, the jury delivered a firm verdict.
They did. On June 7, 2002, Michael Skakel was found guilty of murder. He was subsequently sentenced to 20 years to life in prison. He was then transferred to the Garner Correctional Institution to begin serving his sentence.
And for the Moxley family, this brought a form of closure after decades of waiting.
But for Skakel, it simply marked the beginning of a profound legal fight.
The conviction was far from the final chapter. Skakel and his legal team immediately initiated a series of appeals that would send the case through a decade and a half of judicial turmoil.
The initial appeals, filed in November 2003, focused on three major legal pillars. First, that Skakel, being 15 at the time, should have been tried in juvenile court. They argued the Superior Court lacks jurisdiction.
And second,
They claimed the statute of limitations for the crime had expired. And third, they pressed that issue of prosecutorial misconduct, specifically citing the multimedia presentation during the closing arguments.
but these first few rounds of appeals were unsuccessful, which really demonstrates how high the bar is to overturn a murder conviction.
They were consistently denied. In January 2006, the Connecticut Supreme Court affirmed the conviction, rejecting all three of those major claims.
So then Skakel's team tried to take it to the U.S. Supreme Court.
They did. They petitioned for a writ of certiorari, which is essentially a formal request for the Supreme Court to review the case. But in November 2006, the U.S. Supreme Court declined to hear it, which temporarily exhausted his most traditional and powerful avenues of appeal.
During this time, the media narrative was complicated by the highly publicized efforts of his cousin, Robert F. Kennedy, Jr., who became a central figure arguing for Skakel's innocence outside the courts.
RFK Jr.'s involvement was a significant driver of public discourse, even if it wasn't evidence being presented in a courtroom. In 2003, he published a highly controversial article titled "A Miscarriage of Justice."
What was his argument?
He insisted that Skakel was innocent and argued that the indictment was primarily a reaction to an inflamed media rather than solid evidence. He argued that there was stronger circumstantial evidence pointing toward Kenneth Littleton, the live-in tutor.
And he also explicitly targeted the author, Dominic Dunn.
Yes, he claimed Dunn was the driving force behind the prosecution because of his fascination with the case and also his own personal grief over a daughter who had been murdered. And our sources confirm he continued to push this narrative for years, later publishing the book Framed in 2016, which reinforced all of these claims.
So while the legal appeals are happening, there's this parallel public relations battle being fought.
Very intense one.
And the defense's efforts to introduce a third-party suspect brought an explosive new layer to the case in 2007. This centered on a man named Gitano Tony Bryant.
This was a fascinating and highly sensitive part of the legal saga. Tony Bryant was a former classmate of Skakel's at the Brunswick School and also a cousin of the NBA star Kobe Bryant. In 2007, Skakel's lawyers sought a new trial based on hearsay evidence, a videotaped interview Bryant had given in 2003 to a private investigator.
What exactly was the nature of Bryant's claim?
Bryant claimed that on the night of Martha Moxley's murder, a friend of his had intended to sexually assault her.
A completely new suspect.
A completely new theory. And crucially, Bryant testified that he had not come forward earlier, even after the case became famous, because his mother had sternly warned him that as a young black man in Greenwich, he would inevitably be framed and targeted for the unsolved murder.
So this testimony brought issues of race, class, and perceived judicial bias right into the heart of the case.
It did. It suggested the possibility of yet another potential perpetrator and a system that might be biased against him.
How did the courts ultimately deal with this volatile new claim?
It was addressed during a 2-week hearing in April 2007. The Superior Court judge ultimately denied the request for a new trial in October of that year.
On what grounds?
The judge specifically ruled that Bryant's testimony was not credible. The court simply did not believe his account. Furthermore, the judge reaffirmed the original finding that there was no evidence of prosecutorial misconduct in the 2002 trial.
And the appeal of that decision also failed.
Yes, Skakel's team appealed the denial, but in April 2010, the Connecticut Supreme Court panel ruled 4-1 against that appeal as well. The case seemed closed again.
But then the legal strategy shifted entirely. Instead of focusing on third parties or prosecutorial errors, the defense targeted Skakel's own original legal team from 2002.
This is the argument of ineffective counsel, which is a very serious Sixth Amendment claim.
Right. This isn't just about having a bad lawyer.
No, it is a serious legal claim rooted in the Sixth Amendment. It argues that the defense provided was so faulty, so far below a minimum standard of competence, that it violated the defendant's constitutional right to a fair trial.
And if that claim is successful,
the entire conviction is invalidated regardless of the evidence of guilt.
So what exactly did Michael Skakel claim about his original trial attorney, Michael Sherman?
In an April 2013 habeas hearing, that's a proceeding where a prisoner can challenge the lawfulness of their detention, Skakel testified that Sherman was more interested in publicity than in defending him properly.
He said Sherman was basking in celebrity.
Yes, and that he was overly focused on collecting fees in order to resolve his own significant financial problems. Essentially, the claim was that Sherman's personal life and career ambitions compromised his duty to provide a constitutionally adequate defense.
And a Connecticut judge agreed with this assessment, leading to the first major reversal.
Yes. Connecticut Judge Thomas A. Bishop granted Skakel a new trial in October 2013. He ruled that Sherman had indeed failed to adequately represent Skakel.
And the judge's ruling was very critical.
Highly critical. Judge Bishop stated that the defense required attention to detail, an energetic investigation, and a coherent plan of defense, and that Sherman's failures in these areas were significant and ultimately fatal to a constitutionally adequate defense. He concluded that because of this failure, the original judgment of conviction lacks reliability.
This ruling dramatically changed Skakel's status after 11 years in prison. What were the conditions of his release?
On November 21, 2013, Skakel was released on a significant $1.2 million bond. But his freedom came with stringent conditions. He had to submit to GPS monitoring, adhere to periodic check-ins.
And he couldn't have any contact with the Moxley family.
Done. And there were restrictions on him leaving Connecticut. John Moxley, Martha's brother, publicly expressed profound shock and disappointment at the decision, stating his belief that Skakel was still guilty.
But the state obviously did not accept Judge Bishop's ruling and immediately appealed. This led to the first of two reversals by the Connecticut Supreme Court.
The legal instability of the case at this point was incredible. In December 2016, the Connecticut Supreme Court, in a narrow and highly contentious 4-3 majority decision, reversed Judge Bishop's habeas ruling.
And what was their reasoning?
The majority argued that the evidence presented by the prosecution had been overwhelming, and therefore they found that Michael Sherman's legal representation, while perhaps flawed, had ultimately been constitutionally adequate. This meant the conviction was reinstated.
This decision forced officials in early 2018 to ask the court to send Michael Skakel back to prison. But then the Connecticut Supreme Court did something highly unusual.
It reversed its own narrow ruling,
Which speaks volumes about the complexity of the evidence and the differing interpretations of legal fairness.
It really does. On May 4, 2018, the Connecticut Supreme Court reversed itself again. They vacated Skakel's conviction and, for the second time, ordered a new trial.
And this time, they focused on one specific failure by Sherman.
Exactly. They ruled that he had rendered ineffective assistance by failing to contact one specific alibi witness whose name Skakel had provided. This failure, the court determined, deprived Skakel of the opportunity to present a complete defense, thereby making the original trial unfair.
So after this incredible back and forth, Skakel remained free but under the shadow of a mandatory new trial. The decision now rested on the state to move forward, knowing their star witnesses and evidence were 45 years old.
The state faced an immense challenge. They had secured a conviction based on evidence that was fragile, circumstantial, and now twice deemed insufficient to withstand scrutiny regarding constitutional fairness. Could they really rely on decades-old testimony from troubled youth, shifting alibis, and a controversial golf club, and still prove the case beyond a reasonable doubt?
The anticipation for a dramatic second trial was high, but the state's decision ultimately hinged on the reliability of that aging evidence and the legal victories Skakel had secured regarding his original defense.
The passage of time was the silent third defendant in this case. Key witnesses fade, memories erode, and physical evidence becomes much harder to defend against modern legal standards.
And the final chapter of the criminal case closed exactly 45 years to the day after Martha Moxley was murdered.
On October 30, 2020, Chief State's Attorney Richard Colangelo informed the Superior Court that the state would not retry Michael Skakel. This announcement effectively closed the criminal investigation that had dominated headlines for half a century.
What was the primary reasoning provided by the state for this monumental decision?
Colangelo stated clearly that, in his judgment, the state was no longer confident it would be able to prove the case beyond a reasonable doubt.
Just too much time had passed.
That and the successful legal challenges that had repeatedly deemed the original trial counsel ineffective. The state concluded they could not secure a reliable conviction in a new trial. The combination of old evidence and the constitutional failures of the first trial just made the risk too high.
Despite the legal closure, the legacy of the Moxley murder remains massive. This case truly burrowed deep into the public consciousness. It demonstrates a persistent national obsession with unsolved murders involving wealth and celebrity.
Absolutely. The sources show the case was continuously featured across various media platforms. It appeared on Unsolved Mysteries in 1996, the documentary series City Confidential.
And a fictionalized version was famously depicted on the premiere episode of Cold Case.
There was also a 2019 Oxygen documentary focusing on the controversy, and even a 2020 episode of the Crime Junkie podcast. The consistent public fascination demonstrates that despite the legal system letting the case go, the fundamental questions surrounding the factual events of that night in Belhaven, they continue to resonate deeply with the public.
The notoriety of the Skakel name, the unsettling nature of the crime, and the extraordinary legal drama surrounding the appeals ensured that this case became a symbol, not just of a tragic murder, but of the systemic friction between wealth, media influence, and the pursuit of impartial justice.
Looking back across the entire history documented in these sources, the striking aspects are manifold. We see the persistent, agonizing ambiguity surrounding the precise sequence of events.
Right after Martha's last sighting with Thomas Skakel at 9:30 p.m.
Exactly. The sources also highlight the powerful and often distorting role that celebrity and media influence played in keeping this case active, despite the lack of initial police progress.
But perhaps most profoundly,
we witnessed the severe legal complexity resulting in repeated, agonizing reversals of justice over 4 decades, all revolving around a single murder conviction.
it's a case that forces us to reconcile the desire for definitive judicial closure for the Moxley family with the absolute, non-negotiable constitutional requirements of our legal system.
That's the core conflict.
Skakel spent 11 years imprisoned based on a conviction that was twice deemed unreliable because of the inadequacy of his legal counsel. The system ultimately worked to correct a constitutional flaw, but that correction came at the cost of the prosecution's ability to ever retry the case successfully.
The final status, as the sources define it, is highly unsatisfying. Michael Skakel's conviction was vacated, and the state determined that it could not reliably proceed with a retrial. So while he is legally free and without a conviction, the core factual questions of who killed Martha Moxley remain legally unsettled. It ends the pursuit of justice through the criminal courts, but not, in the public's mind.
So, what does this all mean for you as you consider this decades-long process? If the constitutional right to effective legal counsel is paramount, and it absolutely is, then the system must have a mechanism to correct a faulty verdict even decades later. But when the evidence supporting that verdict is 45 years old, becoming more fragile with every passing year, it raises a profound tension.
A difficult question.
When a judgment is overturned due to a legal error, does the pursuit of justice for the victim become structurally impossible because the evidence is simply too aged to meet the strict requirement of proving guilt beyond a reasonable doubt in a subsequent trial? That is the unresolved tension this case leaves us to grapple with.
A powerful thought to consider, and a reflection on the true cost of systemic delays.
Thanks for listening.